Welcome to today's webinar, Standards for Judicial Education on Scientific Topics, sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School. I'm Donald Koshin. I'm a professor of law here at Scalia Law, as well as the executive director of the Law and Economics Center. Today, I'll be moderating the discussion. The webinar today is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focus on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. All of that is centered around the belief that when judges, academics, and policymakers understand economics and scientific methodology, they're more likely to make sound decisions and engage in rigorous analysis that supports the rule of law and the free enterprise system. And our commitment is to developing original, high-quality law and economics programming, like the webinar today, to further enhance an understanding of economics and scientific methodology, and to provide information that's useful in the legal and public policy debates surrounding these issues. We thank all of you for joining us today to be part of that ongoing dialogue. Our panel includes 4 leading scholars and educators who have decades of experience teaching judges about science and how to understand scientific methodology, how to evaluate scientific topics as a non-expert, and how to consider the admissibility of expert testimony. Rather than focus on the substantive lessons that they often give in those past tutorials, however, this panel will focus on the process of teaching judges about these topics. What standards can be employed to ensure that the teachers of judges remain objective educators, rather than using the podium to teach judges how to achieve policy outcomes and overcome scientific barriers to those outcomes? What is appropriate and what is not in educating judges about science? What should be the objective of this kind of specialized judicial education? Is it to empower the judges to understand science or to provide tools for outcome-based decisions? How do you remain objective as an instructor and in the curriculum development? What standards should be used when teaching science to ensure that you do not cross the line into helping judges manipulate evidence or science to achieve preferred policy objectives? What are some good and bad models of judicial education on science, and how can judges identify them? These and many other questions will be explored with each of our panelists today. We will take each in turn, but so that we can reserve time for substantive discussion, I'm only going to give you a brief bio of each. I suggest that you go to the email that you received for this program, as well as the websites that houses this program, to click on their names and to read their extensive bios, which show their deep experience in all of these topics. Our distinguished panel today will proceed in the following order. First, we'll have David Fagman, who's the Chancellor and Dean, William B. Lockhart Professor of Law, and the John F. DeGardi Distinguished Professor of Law at the University of California College of Law, San Francisco. In addition, we will have Jonathan Click, who is the Charles A. Heimbold Jr. Professor of Law at the University of Pennsylvania Carey Law School. And then following Jonathan will be Gary Marchant, who is the Regents and Foundation Professor of Law and Faculty Director at the Center for Law, Science, and Innovation at Arizona State University Sandra Day O'Connor College of Law. And finally, Charles Santerre will be the last to give opening remarks. He is the College of Agriculture, Forestry, and Life Sciences Director for Ag Policy Development at Clemson University, where he previously served as the Department Chair of Food, Nutrition, and Packaging Sciences. The panelists will each offer opening perspectives, talk a bit with each other, and then we will open it to audience questions. If you do have a question at any time during the webinar, please use the Submit a Question Q&A function box at the bottom of your screen. In it, please identify yourself in the text of your message and keep your questions short so that they're amenable to this webinar format to pose to the overall panel. With that, I'm going to turn it over to Chancellor Fagman to get us started.
Thank you. It's great to be with you all. And in particular, I want to thank George Mason University and Donald Koshin for inviting me to participate in something I've been doing for I hesitate to count the years, but about 38 years, and I've been teaching judges for about 25 of those years, and about 20 at the National Judicial College in Reno, Nevada. And one of the interesting things about teaching judges is the realization, certainly post-Daubert, and even under the Frye test, that judges are gatekeepers, but they don't really have the backgrounds for the standards that are necessary for gatekeeping. And so I've always tried to give judges not exactly a checklist, but basically what are the highlights? What are the things that are necessary to understand when you evaluate scientific evidence? And it's a great challenge. I think that we all understand that if you're great at American history or Russian literature, law school is a good option for you, and it's those folks that end up being judges. And if you're good at statistics and math, you may end up as an engineer or possibly in medical school. And so the question is, how do you bring that level of sophistication to what you have to do on the bench? And also for lawyers, practicing lawyers, you have a responsibility to educate judges and fact finders about the foundations and the fundamentals of the scientific evidence that might be offered in a case. I do think, and I want to emphasize that, at least in my experience, most of the real challenges in this area are not rocket science. Most of the subjects I talk to judges about, things like behavioral science or forensic science, or even topics of medical causation surrounding toxicology and epidemiology, most of the problems with scientific evidence are fairly simple and relatively easy to understand. Thomas Huxley, the great scientist of the 19th century, was famous for saying that science is nothing but organized common sense. And I think that we have to keep that in mind, that when you evaluate what's good about the scientific evidence that's being proffered and what's bad about it, really just fundamental good common sense will illustrate and show you where the weaknesses, where the problems are. So for example, even if you go back to the great litigations that created, to some extent, the questions that we're answering today, Daubert, the Bendectin litigation, when you really look at the underlying scientific literature for the question whether Bendectin was a teratogen, whether it caused birth defects, it was extremely weak and fundamentally unsound. Yet it spawned thousands of lawsuits, with the silicone implant litigation, which also was extraordinarily weak. And that spawned over 500,000 lawsuits in the country. And so relatively weak science can sometimes produce astounding litigation results. And that, I think, led to, as well as other areas like DNA profiling, led to a realization in the courts, and certainly the US Supreme Court, that judges had to be gatekeepers and had to understand the foundations of science. I also want to emphasize that I don't think that, and I think sometimes it gets a reputation for this, that gatekeeping can be a partisan affair. Science should not be a partisan affair. And at least in my background and the areas that I've written in, it's both been favorable to corporate defense counsel on the more conservative side, but also less friendly to prosecutors on the criminal side. So my first foray into this area, I wrote my law review note on battered women syndrome. Battered women syndrome is mostly used by criminal defendants, and the weaknesses of it were really quite manifest. And so I think that when you are bringing good scientific standards to bear to evaluate at the threshold whether the science that's being proffered is good or bad, it's really not about partisan efforts. The fundamental questions that are presented are methodological questions and revolve around the scientific literature that's presented. The other point, and this is something that I've been dealing with a lot more in my recent scholarship, there are fundamental disconnects between what scientists do and what lawyers and judges have to do. And I think that that's something to always keep in mind. And here the issues are a little bit more subtle and a little bit more nuanced. And I'll talk about two in particular. One is what we call the G to I problem. The G to I problem is how you reason from group data in science to individual decision making in the law. And there's a fundamental disconnect between what scientists do for a living and what most courts are doing in their livings. And I'll give you a very simple example. We'll take it right from Daubert. The question whether Bendectin is a teratogen, as you all will understand it, is what's called the general causation problem. And so it'll be studied through toxicology, it'll be studied through epidemiology. And the general causation question is, can Bendectin cause birth defects? That's what scientists focus on. And then the more specific question, or specific causation question, is if general causation is met. If indeed, and we now know it's not true, but if it's indeed true that bendectin causes birth defects, the question then is whether the plaintiff's birth defects were caused by bendectin. That's a very different statistical inference that has to be drawn, and that's a specific causation problem. And so the G to I issue is really endemic at the intersection of law and science, because virtually, and again, we know it from day-to-day activities, when you talk about meteorologists, which is essentially just applied physics, the way meteorologists define individual events, they define it as group data. The probability that a Category 5 hurricane will hit Miami is always described as a probabilistic event. Yet in the courts, we very often expect experts to come in and be able to testify to, quote, a reasonable degree of scientific certainty, unquote, that the plaintiff's condition was caused by the defendant's product. And that actually turned out to be a very difficult thing to do, and there may not be very good support for doing that. A second point on this issue of what is to a reasonable degree of scientific certainty, one of the things I often ask judges, what does it mean when an expert says to a reasonable degree of scientific certainty? And judges will invariably say to me, well, don't ask me, ask the experts. They're the ones who are saying it. And then when I meet with expert audiences or lawyer audiences, I ask them the same question. What does to a reasonable degree of scientific certainty mean? And they say, don't ask us, ask the judges. They're the ones who make us say that. And the fact of the matter is it doesn't really mean anything at all. And in science, what to a reasonable degree of scientific certainty means depends on the consequences that flow from making that decision. It's a decision threshold question. So for example, if you're a psychiatrist and the question is whether your patient or client has schizophrenia, that's a diagnostic question that has to be made under conditions of uncertainty. Could be bipolar disorder, it could be other factors that are causing the circumstances that you would suspect that are manifesting as schizophrenia. Well, the question might be, do you prescribe a drug to treat schizophrenia? And the side effects of such a drug might be weight gain, diabetes, and other factors that you'd want to avoid. But the decision threshold of whether somebody is schizophrenic may be relatively low because you can give the drug and observe them day after day, week after week, and take them off the drug if the side effects are too problematic. In the law, the decision threshold might be if they're schizophrenic and therefore mentally ill, does that lead to their civil commitment? And a due process hearing might not be had for another year. And so the decision threshold, the consequences that follow from a diagnosis are different depending on the circumstances. And from a legal standpoint, where you set the decision threshold is really a policy question. And so we all ought to understand that when you ask scientists to make a judgment to a reasonable degree of scientific certainty, you're actually inviting them to make a policy judgment about where the decision threshold should be. And that should be something that lawyers and judges understand, and ultimately will be part of what the legal standards are, whether it's a preponderance standard in civil cases, beyond a reasonable doubt standard in criminal cases, or possibly a clear and convincing evidence standard in quasi-criminal cases like civil commitment. So I'll end it there, and I look forward to the discussion with the other panelists. Thank you.
Thank you so much. And please, audience, remember that you can use the Q&A button at the bottom of your screen. If you have any questions, we will get to them toward the end of the program. Next up is Professor Click.
Thanks, Donald. I teach, I'm an economist who teaches in a law school, and most of what I teach at some point comes back to questions of causality. How do we figure out causality? In terms of thinking about how lawyers and judges in particular, can they do this, or what can we expect? What can we hope for in teaching? It's interesting. I come back to in one of Dick Posner's 9 million books. He has a phrase when he talks about kind of what lawyers should know or what law students should know. He says, for him, the most important thing that we could teach law students would be statistics. He says, it shows up everywhere. The ideas of causality show up everywhere, and lawyers and law students, we don't kind of prepare them. And as an aside, he sort of says, if you need to make room in the curriculum, we could get rid of con law, right? That's all made up anyway. Yeah, I don't know that I'd go quite that far, but it does sort of at least ring true to me. But it actually goes beyond lawyers and judges. I at one point, I've got four sons, and when they were little, I used to wonder, why in the heck are we spending so much time making sure they know all 50 of the state capitals, right? And when is that ever going to matter in their day-to-day lives and how they kind of think about the world? Whereas things like statistics, we generally skip. Lots of students don't even get anything about statistics and causality. Now, maybe one of the reasons is this stuff's hard, right? We don't teach physics to everyone. We don't teach a lot of stuff, rocket science to everyone. Importantly, though, I think for most people, and certainly for lawyers and judges, the ideas of causality and how we think about them statistically are doable. I've taught at every level that you can imagine. I've taught community college all the way to graduate econometrics, the Ivy League to Prince George's Community College. And I think across that wide span of folks, people have, as long as we don't kind of make statistics at least fancier than it needs to be, we can impart some important lessons. So luckily for lawyers and therefore judges, our ideas of causality and statistics actually map really nicely into the way we think about causality in the law. Causality and causal inference in statistics, at least the primary kind of paradigm these days, is but for causation. Exactly the same kind of causation framework we think of in torts. And so, to kind of get that mapping right and show, hey, if you understood this in torts, you can probably understand this in statistics and start and focus on these kinds of intuitions, right? So, when I teach torts, you talk about, well, but for causation is, we see what actually happened, we rewind the tape, we remove the negligent act, and then we run the tape forward. Are the outcomes the same or are they different, right? That's the way we, at least for the last 20 years in econometrics and applied statistics, have taught and thought about causality. And so, if you can get that fundamentally, you can sort of understand the enterprise that we're working on. And now maybe it gets a little bit harder when we start talking about, easier said than done kind of stuff. How do you rewind that tape? How do you come up with the proxies or the comparators to give us some sense of what that but-for world would look like? And what I do is certainly when I teach judges, when we get sort of an hour or 3 hours in the course of a day, you obviously can't sort of walk through everything. But I do think some of the best papers that sort of really resonate with people, really have an impact, they do so mostly not because of their fancy technical kind of pizzazz. It's mostly because they sort of really do hit an intuitive notion for people, right? And so what I tend to talk about, okay, let's start at the very beginning. What would we do, or how would we think about if we can run a real experiment, right? If we can actually randomize, and sort of how would we make sure that sort of fit what we needed to meet sort of methodological rigor and things like that. But assuming it does, and those things are important. Obviously, the judges might have to make some determinations whether those thresholds have been met. But assuming it does, why do we believe? Excuse me. Why do we believe that an experiment, an actual randomized control experiment, gives us something like that but-for proxy, that sort of good basis for sort of thinking we've identified a causal relationship? And then what I do is I sort of say, okay, that's great when it's available. Although then, of course, we can run into sort of the issues of relevance and sort of the sort of artificial nature sometimes that we have in experiments, and we need to deal with that. But in general, if this kind of experimental randomization type study is available, great, sort of go with it. But lots of times we don't have such things, right? Certainly in the policy context, but even in some of the contexts that sort of show up in even tort law and other places. And so, how do we sort of move into what the economists sort of speak of as natural experiments? And sort of, I keep trying to sort of tie back into that original intuition. And the benefit of doing that is to sort of say, okay, if you believe the real experiment, in what ways do the natural experiments sort of differ and in which ways are they similar? And so then you can start to think of, is it close enough or is it too far? In which ways am I worried? In which ways do I sort of feel better about things? Now, when I teach, sometimes the big worry that you have with sort of the non-specialist audiences is that things will get sort of too abstract. And so what I like to do is I like to focus on sort of what I think of as particularly salient examples. So in my last sort of 2 or 3 minutes, I'll give you one of my favorite examples. And I use my own work because I tend to think about, well, then I can talk about, here are the problems that we ran into. Here are the things that, we felt good about. Here are the things we didn't feel good about. And sort of making that connection, allowing the judges to sort of see that sort of thing, I think is really helpful in getting this intuition. So very quickly, the paper I've come to use most recently is a paper we did a year or 2 ago. We're looking at this issue of what is the effect of alcohol on crime. Now, it's a topic I think most people can sort of think about. You can say, oh, geez, I've seen people get drunk, or I've been drunk, and you can sort of imagine all the ways that it sort of affects on crime. But also then you can immediately sort of tell people, yeah, but you think about who are the kinds of people who tend to get drunk. Do they do the kinds of things that are related to crime even when they're not drunk? And so that gets to the idea of omitted variables and that sort of thing. And then I can also say, well, look, what would an experiment look like in this, right? It's not as though we're going to randomize and get lots of people drunk and say, hey, have at it, right? And so, it gets a lot of the points across, and sometimes we just don't have the randomized experiments that are useful in this context. So what did we do? What we did is we sort of came up with the following idea and intuition. In US professional sports leagues, we use baseball, but they all do it. They stop serving alcohol at a certain point in the game. The interesting thing is for baseball, right? They stop selling at, say, the 7th inning. It differs team to team. The 7th inning is sort of the standard. The interesting thing about baseball, right, is that the 7th inning to the end of the game could be 20 minutes. It could be 6 hours, right? And it's going to largely be independent of anything that we could possibly think could matter for crime otherwise. And so we can use that as if it's an experiment, as if we were doing the randomization ourselves, right? And I think by focusing on sort of these kind of very simplistic examples that sort of resonate with sort of everyone, I think, in some sense, we can sort of demystify and then bring home the intuition of how do economists, how do the non-experimental scientists in particular, how can they sort of figure out, do we really know what we think we know? So that's where I'll stop, and I'm interested in what further discussion we'll have.
Thank you so much, Professor Click. And now we'll hear from Professor Marchant.
Great. Thanks for inviting me. I'm delighted to be a part of this interesting discussion. So first of all, I mean, there are standards for this issue of private organizations creating educational programs for judges. There's a number of different things. There's the Judicial Conference has a policy on judges' attendance at privately funded educational programs. There's an ethics opinion by the U.S. Judicial Conference Advisory Committee on Codes of Ethics for Judges. There's case law. There's an important case in the Second Circuit a couple decades ago on these issues. And if you read all those materials, there's a consistent theme and sort of two-part. The first part is that judicial education is important. And as David said with Daubert, judges performing a gatekeeping function. With all these emerging technologies we have today, our regulators, both in the legislatures and regulatory agencies, are slow to adopt rules. And yet these technologies are out there in the real world, whether it's AI or blockchain or genetics and so on, having real world impacts. And there's really no rules out there adopted by legislators or regulators. So the courts are going to be sort of the front line to deal with some of these social issues. They don't want to be the regulators. They like to be applying the law. But the reality of today's world, where technology is moving so fast, is often we rely on the courts to be the regulators, because the legislators and regulators are too slow. And I don't blame them. It's tough but they have the option of punting. The courts can't. If it comes to the courts, they've got to decide it unless they got a procedural out. So it's really important that courts then that are performing this very important role when it comes to technology like AI, sort of being the centerpiece of a lot of our current policy debates about AI, have the understanding of this technology. And as David said, most of the people going into judgeships don't have a technical background. And so they need some expertise, they need some training. And all of these different standards all recognize this, that there's this really important function for judges to be educated. And even if it involves some kind of viewpoint. So the ethics opinion, advisory opinion number 67, expressly says that a lecture or seminar may emphasize a particular viewpoint or school of thought does not necessarily preclude a judge from attending. Judges are continually exposed to competing views and arguments and are trained to consider and analyze them. Judges are smart people. They know when they're being sold a bill of goods, when they're being essentially advocated. But these standards, the second part of them is they do recognize there's a line that you can cross a line to advocacy, to interference, or the perception of the reality of basically interfering or predisposing a judge to a particular viewpoint in a particular case. And the question is, where does that line get crossed? And it's a fuzzy line, and it's hard to expressly define. And all these documents, again, recognize that there's a fuzziness to that. And it's really a case-by-case judgment. And it really comes down to sort of four factors. Who is the institution putting on the training? There's some official judicial education entities, the National Judicial Center, the National Center for State Courts, the National Judicial College, the state judicial education bodies. Their job is to educate judges. And so when they put on an event, that should usually be not a problem whatsoever. But they can't do it all. They can only do part. They have limited budgets, and what they do is very valuable. When I talk to judges, it's mostly in one of those institutions. But that's their job. And again, there usually isn't big issues about that. The second tier of organizations are things like the Law and Economics Center, academic institutions. And again, this is a little bit more higher risk than an official judicial body, but they're still, fairly objective. They're an academic institution. They have standards of academia. They often will have a particular focus or theme or even direction, whether it be economics or environmental or social justice or technology that they're trying to convey to the judges. They're obviously think it's worthwhile talking to judges because they want to influence litigation. They want to influence the judge's decision-making, but hopefully in a good way, in a way to help them make up these decisions more informed. And then the third thing would be more adversarial parties, a law firm, a company like a pharmaceutical company, insurance company, an environmental organization. Those clearly have an interest, whether it's ideological or financial, for particular outcomes. And those would be the highest risk type of institution. Doesn't mean they can't do it, but you've got this sort of tier of different types of institutions that you got to look at in this balancing. The second thing is disclosure, that there needs to be disclosure of interests, of who these organizations are funded by, who are the individual lecturers funded by, and that the judges then also disclose to their courts the things they go to. So that's a second factor. Is there full disclosure of who is there? Third is the topic. How closely aligned is this with specific cases that judge may hear, either in their docket currently or are likely to happen in the future? If it's talking about, historical examples like Benedictine or silicone breast implants and the lessons we learned from that, that's less of a concern than if they're talking about something before the courts now, like PFAS or global warming or things like that are the current subject of litigation. So again, you can learn a lot of important lessons sort of looking backwards and not talking about the cases that are in front of the judges. But again, it's not an absolute rule. You could have judicial education about some of these current topics. It's just that they're more high risk. And then the fourth factor is balance. Is there some attempt by the sponsoring organization to have competing views, particularly in these cases that are really currently before the judges? So I think it's a case-by-case determination whether it's appropriate or not. The Second Circuit case in re Agrienda talks about this. They say you have to look at this on a case-by-case basis. Judges should be wary of attending presentations involving litigation that is before them or likely to come before them without at least, very least, assuring themselves the parties or counsel to the litigation are not funding or controlling the presentations. And then if they're not, then that's more acceptable. And so again, judges and the sponsors of these programs have to, I think, consider these 4 factors. I personally decided 20 years ago when I first started my first judicial education program, never to accept any consulting or expert witness fees or any money from law firms, just to keep myself completely free of any prejudice or conflict of interest. I was a lawyer for 10 years and I somehow always thought my client was in the right. I know how that affects your brain. I was moved by a guy named James Wilson, who was the head of gene therapy at University of Penn, who was in charge of the Jesse Galsinger treatment, who died, this 19-year-old from Arizona who died. And he said at the time he was outraged. He was accused of having a conflict of interest. And he said, of course not. I'm a good scientist. And then 10 years later wrote this mea culpa and said, yes, when I look back, I did have a conflict. I didn't really even realize it at the time. So I do think money does infect your brain, and it doesn't mean that someone who is getting funding should not be allowed to talk. But I personally find it useful sort of just to be clear of that and have no conflicts whatsoever. And then secondly, in my own work with judges, I speak about 10 or 12 times a year to judicial groups. I never tell them the outcome that I think should be the outcome of these cases. Often I don't even know. I think the hard part is figuring out what the result should be, but that's the judge's job. What I like to talk about is, what is this technology? How is it developed? What does it do? And then what are the types of legal issues it may create? Like, for example, in genetics, there's all kinds of things that come before courts. For example, there's criminal cases where there's a particular gene, MAOA, that may predispose someone to violent crime if they had a certain upbringing. But that's not clear cut what the meaning of that is. So there's questions about the noisiness of the data supporting it. And then even if you do accept that it does have this trait, there's the question of, so what should that matter to the outcome? So I will set up those issues, but I won't decide them. I don't even have an opinion actually of what the outcome should be. Or similarly, when I talk about AI, which is now what all the judges want to hear about, you can talk about, this data scraping issue. There's something like 15 cases before the courts right now. Is that a copyright violation or is that fair use? Again, you can set forth the issue, you can set forth the arguments on either side, but I would never tilt it and say one way it should, this way or that way should be the outcome. And again, frankly, I don't know which way those cases should be decided. So again, I think it's, as long as these sessions are not involved in advocating for particular results, even if they have some ideological or disciplinary trend, I think they're incredibly useful for judges, and I think judges need this at this time. And again, I trust judges to know when they're being told what to do as opposed to being educated.
Thank you very much. And we'll turn to Professor Santerre. I do want to mention that all of you received a reminder email this morning about this webinar that includes a link to a slide deck that Professor Santerre will be referencing. It will not be displaying here on the webinar just for clarity purposes, but please do feel free to pull that up now, or you can go to masonlec.org where it is available on the webinar webpage, which is also accessible through your email. And so lastly, I'll just say it's going to stay up there on that webpage in case you want to look at it after hearing the presentation. So with that, Professor Santerre, I turn it over to you.
Good. Thank you, Donald. And thanks to the Law and Economics Center for the invitation today. So I'm going to kind of walk through my slides. I always come with too much information and too little time. So the first slide, or the second slide I'm showing you, gives some benefits of a herbicide called glyphosate, commercially known as Roundup. And I want to do a little bit of a walkthrough of this, of what's going on with Roundup or glyphosate over the last decade. There have been some very large lawsuits involving this herbicide. And as a scientist, I see this and I look at it, I'm always scratching my head. So let me walk through. So in 2015, a lot of the brouhaha started when the World Health Organization's International Agency for Research on Cancer, also known as IARC, categorized glyphosate as a group 2A carcinogen, or probably carcinogenic to humans. Now, one of the big limitations of IARC is they don't consider exposure. So they basically are looking at, could this chemical cause cancer versus is it likely to cause cancer? And that's a big difference. So they'll dose animals or they'll look at studies where animals are dosed at very high levels, and you give just about any chemical to an animal, it'll have deleterious effects, sometimes cancer. There was a very good review by EPA in 2019 looking at glyphosate, and they ruled that it's not likely to be carcinogenic to humans. But some of what IARC does echoes around the planet. So in 2021, Vietnam became the only Asian country to ban glyphosate, and the European Food Safety Authority, EFSA, has been looking at this, and the European Commission is now saying we should probably approve it for the next 10 years. But the debate right now in Mexico in 2024, Mexico plans to ban glyphosate by the end of this month. And US has filed for consultations with Canada joining as a third party, saying that Mexico's decision is unscientific and violates USMCA. And when I look at what Mexico stated in some of these documents, there's not a scientific basis for saying it's an unsafe chemical. So moving to the next, a journal article that just came out this month in Pediatrics, which one would think would be a very reputable journal, basically is telling pediatricians to not feed or to feed their children organic foods to avoid GM. And the scientific basis for this is just not there. Actually, the risk from some of the organic products, which could be higher in mycotoxins, could be greater. But biotech will eventually pass organic foods in that they will at some point be safer and more nutritious than organic foods, which do not allow the biotech standard. NGOs have been very critical of biotech. In 2002, one of the things that I found very distressing is that in Zambia, there were 3 million starving people, and they rejected US biotech corn that we shipped to them as relief. And what bothered me as much was that Greenpeace applauded the decision. And I guess I'd like to suggest that Greenpeace probably hasn't gone to bed hungry. And yet this corn that we eat every day in the United States was shipped back. And then there's a statement from Michael Hansen at Consumers Union is there hasn't been enough research to determine whether GMOs are harmful to people. So they've been beating this drum for a long time. So I was at a conference with Michael Hansen back in 1999 at the University of Illinois, and there are a number of NGOs representatives sitting around the table, and I was pounding them. I says, this is good for the environment. It's good. Less pesticides are used. There's less erosion. Everything that's showing good for the environment. Why don't you support these? And Michael pulled me aside and he said, Charlie, it has nothing to do with the environment. It has to do that we don't like large multinational corporations. When he said that, the light went on over my head and I was like, oh, I get it now. I understand why this fight against GMOs. So attorneys for plaintiffs estimate that approximately 4,000 lawsuits have been filed under the US right to know, although it's rather difficult to estimate the number of lawsuits involving glyphosate. There is a statement I'm quoting here. The evidence that glyphosate is currently causing non-Hodgkin's lymphoma in human beings at current exposure levels is pretty sparse. And Monsanto judge says that expert testimony against Roundup is shaky. I'll show you a little bit of evidence to that. So when we look at from the scientific standpoint, we use the scientific method to test hypotheses, to refine our hypothesis. But it's important that scientists make sure that they try to be free of bias, that their work is repeatable by independent groups, and that they're of sufficient statistical power. And so oftentimes you find studies that fail in one of these three things and can tell us things that just aren't true based on scientific evidence. There is a way that epidemiologists tend to look at the weight of evidence, and they use these meta-analysis. And this is a statistical analysis of a large collection of analysis results from individual studies for the purpose of integrating the findings. And like one of our speakers talked about earlier, a lot of these are just common sense. So back in 1965, if you wanted to develop a causal relationship, you should try to meet as many, if not all, of these Hill criteria for causality. And so I won't spend much time talking about these, that there's a lot of correlation out there, but oftentimes it's much more difficult to demonstrate causality. So here's a meta-analysis that was done on glyphosate. And in contrast to what the IARC found, which eliminated a few of these studies, there's just no relationship here. So at the very bottom right on here, those who have the slides, if the coefficient of variation includes number 1, it's generally not going to be significant. And so the overall of these different studies was that there was not any evidence based on epidemiological data to show a relationship between glyphosate and non-Hodgkin's lymphoma. And then we get even a little bit more with the next slide, which over time, you can see how much glyphosate usage has gone up. So between 1974 and 2014, glyphosate usage has increased by 200-fold. Now, if you see that kind of a usage, you'd expect, well, maybe if there's a relationship, a causal relationship with non-Hodgkin's lymphoma, we'd see an increase in incidence of this disease. And so from 1992 to 2014, there's no change in new cases of non-Hodgkin's lymphoma. So the evidence just really isn't there to support even a relationship between these two. So here's a few wrap-up points I've got. After billions have consumed GM crops, billions of people on the planet, there's not been a single illness attributed to the consumption of these foods, including GM soy that's been sprayed with glyphosate. Biotechnology is critical for international food safety. I think that would be a good conference just to talk about how important biotechnology is to prevent crop failure in the United States, but also in other countries. A weight of evidence assessment demonstrates that glyphosate is safe when applied according to the product label. The decisions surrounding glyphosate should be a wake-up call that our judicial process needs to improve. Courts are being influenced by those driving the agenda, including agencies, journals, companies, NGOs, and scientists. This next one, I'm not sure how it's implemented, but if it's possible, a scientific expert could serve as a friend of the court to help better understand the technical aspects of these cases. And then something that just came across my desk today was an article looking at talcum and the Johnson & Johnson case, and talked about this change that happened in December to the Federal Rule of Evidence number 702. And the quote from the article is, "In making bold claims, witnesses must provide strong and sufficient evidence to support and show their work." And so I've cited that in the last slide of my presentation, that it may be a little more difficult for some of these agenda-based individuals to make it in front of the court. And I'll conclude right there.
Great. Thank you all for getting us started on this conversation. I want to open the floor to each of you. If you've heard something that either any other panelists said that you thought you'd like to respond to, or additional thoughts that you thought of along the way that you'd like to interject before we move to the audience questions. Yes, Dean Fagman.
So thank you. These were great comments. Just a couple of things. I want to add on to Jonathan's point about statistics. So I absolutely endorse his view. I would add, and he kind of implicitly discussed this, hypothesis testing. I think that one of the things that undergraduates really need to be schooled in is how you do real experiments versus natural experiments or quasi-experimental designs. And hypothesis testing is really key to that. Another point I would make is you all judges need to realize that they are the market for a lot of scientific evidence. This is especially true on the criminal side. There are a lot of repeat players, whether it's handwriting identification, bite mark identification, tool marks in firearms, fingerprints, DNA profiling, mixed samples DNA. And if the courts are not sophisticated consumers of science, then the science is not going to improve and get better over time, which is the nature of the scientific method. And so judges really do need to be gatekeepers because they need to demand that good science continue to be done over time, and that's especially true in feature comparison areas like handwriting or firearms and tool marks, where artificial intelligence and computer graphics will eventually help a lot. And then finally, I will say, and I know judges don't like to be using court-appointed experts. Charles raised that issue. I do think that when the science is particularly complex and difficult, having court-appointed experts under Rule 706 or technical advisors under Rule 104A is a good way to go. And I think there are ways to do it to ensure that the experts are non-aligned and as neutral as possible. So thanks.
Yes, Jonathan.
So I'd like to maybe push on one thing that I think I heard Gary say when he was sort of talking about the different types of organizations that do judicial training. He sort of said, you know, these public organizations, they're sort of like the first best, and then these other ones have some additional worries. And I just wonder, I don't have particular, I've never taught for the public judicial education groups. I've never even sat in them, but I know enough of dealings with NIH and you know, other such groups. They absolutely have sort of prejudices and biases. And so I just sort of maybe want to push back a little bit, or at least hear more of what Gary's thought is there. My own kind of bias is to say, it's, you know, all these groups have their biases, and it's best to have this sort of marketplace of judicial training.
Yeah, so most of these official ones basically are funded by, you know, public funds, and the committees that are in charge of judicial education are the judges themselves. So they're basically determining what it is they want to hear about, what's important to their state or their discipline, and so they are deciding the topics, they're deciding the speakers. And so it's much different than, say, even an educational institution that has maybe more knowledge of a field, but has more of a perspective, a particular viewpoint. You're not going to see that very often in the judicial committees. I mean, every person obviously has their own political and issue biases. And, you know, when you get on a committee of 5 judges deciding what their annual meeting this year will talk about, those individual biases will be, you know, in play, but they'll often be countered by the other judges on the panel, and they basically know what they want education about. They know the type of cases they're dealing with. They know the type of issues they need to help with. So to me, they're the least concerning group to fund these or to put on these events, because it's the judges themselves who are deciding this.
Any other reflections on the part of the panel? I do want to invite the panel to offer suggestions or other ideas for judges who need judicial education in a case or on the fly. So David, you've given us a couple examples there. I'm wondering thoughts on the panel of things like science days or any other mechanisms by which judges, when they are confronted with some scientific uncertainty or otherwise, can identify during a case means of educating themselves.
I'm happy to jump in a little bit, Donald. I think that judges are disinclined to want to learn about the specific science in a case while the case is happening, and I certainly understand that. But there is a debate about whether judges should be educated about the general issue that's before them as opposed to the specific question. And so, and I'll push back a little bit on Jonathan's point about the but-for causation being not unusual as between a tort suit and scientific research. I think that they're actually quite different. The question of whether bendectin is likely to cause cancer is a very, very different question of whether the plaintiff's cancer is caused by bendectin or birth defects or whatever it might be. And so the statistical inference that goes along with that is quite different. I do think judges have the latitude to study the general issues before them, certainly get up to speed on epidemiology and toxicology. One of the panelists talked about the dose being the poison, that anything, including water, will kill you if you have a large enough dose of it. So the general educational parts of what the science is before a judge, I think, is very much fair game and can be considered. The other point that I would make, which is something that we don't do in the United States, Australia has a very interesting process. They call it hot tubbing of experts. And so they'll bring in experts having different views, different perspectives, and they put them all together and they talk to one another. And the judges have the opportunity to engage with the experts, and the experts have the opportunity to engage with one another. And the fact of the matter is, when you put the experts together, the scope of disagreement ends up narrowing greatly. And very often what that narrowed scope is where the judge's decision really needs to be exercised. So I would love American courts to consider this kind of hot tubbing idea where you bring in several experts to have a conversation about glyphosate and Roundup or something else. And I do think that what we know now is most likely to come out best under those sorts of circumstances.
So Donald, one thing I might suggest is, to the extent when judges think about hiring their clerks, judges tend to try to replicate, which is absolutely wrong, right? In this sense, right? Why would you get somebody that kind of does the stuff that you do well? And if you take, say, at a place like Penn, let's say 20% of our students have some quantitative background, they don't necessarily end up with the highest grades, because, you know, what's an engineer care about con law? What's an economist care about, something else? But they can be much better at this sort of stuff. So I would suggest to judges, to the extent they have the ability, seek out for clerks somebody with these kinds of backgrounds.
And if I could just jump in there, I agree with David that the hot tubbing is an interesting idea. It's something that, for example, the Navajo tribe's been doing for centuries here in Arizona. But there's also been some examples recently in the U.S. litigation of judges requiring that, and it seems to work quite well. The idea of a science day, which you mentioned, Donald, is also another, I think, important mechanism where you basically spend a day with the judge, just having the experts explain the basic science behind this. I often wonder why we don't expand that to also include the jury in a jury trial, because the jury is the ultimate fact finder. Wouldn't they benefit from that as well? And then, the court-appointed experts, another mechanism. And then, something that a former colleague of mine who's now retired, David Kay, he wanted to recommend is that we have to have a public repository of expert reports, because so many expert witnesses will say something in the literature and say, therefore, I'm peer-reviewed, published in the literature, and then say something far more extreme in their expert report that's only going to the court. It doesn't see the light of day. If we put those on the internet or made those public, I think experts would have to be a lot more constrained and a lot less sensational in some of the things they're putting in and telling judges. And then just the final thing, going back to something that David said earlier about sort of being a sophisticated connoisseur or user of science. When Daubert was decided, sort of a great sign of good science was it was peer reviewed and published. But since then, we've got this proliferation now of pay to play, basically junk journals. They sound like a scientific journal, but they will publish anything if you pay them, $500 or $2,000. And so you're getting a lot of really terrible stuff published in these so-called science journals that don't meet the criteria of a good science and legitimate journals. But it's very hard to tell just by the title of the journal, because they basically make the title sound like it's a real science journal.
So two quick things. I would be neglecting my duty if I did not mention, and after Jonathan's excellent suggestion about clerks, that every student at Scalia Law goes through an economic analysis for lawyers class and is trained in the scientific methodology. So please do consider that out there. But on Gary's point, we have several questions. A bunch came in here at the end. I can group a few together, though, because they really relate to that last point you just made, Professor Marchand, and that is there a way to educate judges about how to identify biased or funded research and or research that is put in specific journals for specific purposes of influencing litigation? How do you educate judges about those online type journals? And I want to reiterate what Gary said to everyone out there, because judges probably don't know this. We get emails in our inbox all the time that are telling us, hey, come publish with, we'll publish your paper. We will. And there's
Peer
all the,
review in 2 hours.
yeah, right, exactly. So there are people out there at these very fancy sounding journals that are trying to make money by getting us to, or getting the people who can't publish in legitimate journals to publish in their works. So how do we educate judges about identifying biases or quality of science?
Well, I would say judicial education seminars about the scientific process, and to talk about, there's directories of these journals, that a lawyer, the other lawyer or the judge can look and see, this article you're citing as sort of this authoritative source. Where is it published? Is it on one of these junk journal lists, or is it a legitimate science journal?
I'd like to add a little bit of a caution also. So there have been very respected journals have really bad articles in them. So we had
True.
the MMR vaccine causing autism that occurred. That was published in the Lancet, probably one of our top 4 journals. It took 2 years for the journal to retract that. Science did one in the last decade looking at PCBs and farm salmon, scared people from eating farm salmon. It was, Science is one of our best journals. It was a terrible article and it had a real agenda behind it. So we get these, and Nature had the story about how BT corn was killing monarch butterflies. And then about 20 labs did studies that showed exactly the opposite. So it was very expensive for that statement. Even our reputable journals have these failings on occasion. I can't tell whether there's an agenda there, but you have to be aware of all journals, I think, at some point.
Any other thoughts on that question? Well, let me turn to another then, and I'm not sure that you can answer this directly based on your own expertise, but maybe you can help judges figure out how to answer it from evaluating the science. An anonymous attendee has asked, in instances where scientific evidence is complex and contentious, particularly in cases involving public health or environmental risks, should judges adopt a precautionary principle approach? And I guess I would ask all of you, is there anything from teaching science that would support that, since that really is kind of a policy decision? But then the question continues, specifically in situations where there's scientific uncertainty or contested data, is there a judicial responsibility to err on the side of caution to safeguard the public interest? And how might this approach be balanced with the principles of justice and fairness to all parties involved? Again, I'm not sure that you can decide how to answer that question, but can you help judges understand how science can help them answer those questions?
So I don't know, it's a big question, but one point that I'd like to make is, and this happens as much in policy or maybe more than in law, but sometimes in law, you can have scientific inputs to a decision rule, but the scientists aren't particularly good at decision theory, right? They're not good at trade-offs, or not that anyone is particularly necessarily better than anyone else at trade-offs. And scientists, we've seen in sort of recent experience, blur those lines quite a bit and sort of rely on their scientific mantle to say, we should trust me because I'm the scientist, when really it's a trade-off question or a decision rule question.
Yes, I would add, Donald, I think it's a great question. I think the problem is it's very difficult to anticipate what the consequences are and how to be cautious. So take Bendectin as an example. Merrell Dow Pharmaceuticals took Bendectin off the market largely because of the litigation that blew up in the late 1980s and early 1990s. Taking Bendectin off the market, Bendectin was a drug used for extreme morning sickness. So women ended up taking other drugs that may have done much more damage than Bendectin was ever accused of doing, and Bendectin is now back on the market. And so I always use the example from meteorology. If you are told that there's a 45% likelihood that a Category 5 hurricane is going to hit Miami, and your models give you 95% confidence in that estimate, do you evacuate Miami? Well, if you're right, you get a true positive, and you evacuate, that's great. If it turns out that you were wrong and you evacuated Miami, then there are major consequences that flow from that. So there are consequences that flow from the any kind of either correct answer, true positives and true negatives, versus false positives and false negatives. And I'm not sure that judges or lawyers generally are very good at estimating what all those are. I think in most of these areas, I'll just finish here, most of these areas, the science that is bad science that's coming in simply does not rise to a threshold of being fundamentally sound. And there, I think the courts need to step up. And again, bite marks is kind of the paradigmatic example that why any court today is allowing bite mark evidence into court is just shocking to me and is an embarrassment to the system.
Oh, you're muted, Donald. Donald, you're muted.
Oh, Donald, you're muted.
Sorry about that. I was saying that we are at time, but I did want to give everyone a chance to give a 30-second final bit of advice or a final perspective to offer. So, Charles, can we start with you and go to Gary, then Jonathan, and then David?
Okay, I guess the last question, really, I think it's important to be cautious, but the precautionary principle has caused a lot of challenges to products that would benefit populations from getting into the marketplace. And I would argue today that some of our federal agencies have gotten too cautious in approving some biotech products that have demonstrated benefits for the public. And so I think it's that be careful about the opportunity cost when weighing which side on these issues to be on.
Gary, any final thoughts?
Just to reemphasize the point that courts are probably the least equipped institution to deal with these technical scientific issues because they don't have scientific staff, unlike legislatures and regulatory agencies. They don't have scientific experts making the decisions, and yet we're calling upon them to make so many critical decisions in the science field today. So we need more judicial education, better ways to help judges deal with the cases coming before them.
Jonathan.
So I just want to reiterate my point of we should be more careful about separating the normative or policy or trade-off choices from the scientific inputs. And I think lots of people have blurred those lines if they even recognize them to begin with.
David?
I'll just end by saying science is really interesting. It's fun stuff. There are some great science writers out there. Edward O. Wilson, wonderful books. Robert Sapolsky. I would say judges need to start spending their free time reading great science writers.
Excellent advice. And thank you all for joining us. Thank you to our panel for their perspectives and expertise being shared with us today. Thank you to all of you for sharing your time to be with us. If you'd like more information about the activities in the judicial education at the Law and Economics Center, please visit masonlec.org. That's masonlec.org. If you'd like to contribute to help support some of our judicial education and other products, you can also do so there. I also noticed that we did not get to many of the comment or questions in the Q&A box. I apologize for that. There's always more to discuss than we have time in an hour. If any of you would like to reach out to the panelists, I'm sure they'd be happy to hear from you. But I also noted a couple of folks who had firsthand perspectives on judicial education that were offered in the comments as well. And we invite all of you to share any of those with the Law and Economics Center, both to help us improve in our judicial education, but also for us to understand and know the landscape of judicial education that you all are using out there. So I invite you to email me at dkoshin2@gmu.edu if you would like to share any of those perspectives. And we look forward to seeing you at our next program very soon. Thank you all. This is the 50th anniversary year of the Law and Economics Center. We were started in 1974, and we can only continue this because all of you are there to carry on with us in our conversation. Thanks again, and have a wonderful weekend.